Estoppel explained what the UK Supreme Court's latest decisions mean for offshore litigation. The UK Supreme Court has recently delivered judgment in Skatteforvaltningen versus MCML Ltd, which has helped focus the parameters of estoppel together with previous landmark decisions such as Tinkler versus HMRC. Estoppel by convention, Harneys' article on Tinkler can be viewed here, and guest versus guest, regarding proprietary estoppel. Harneys' article on guest can be viewed here. In this article, we analyse the key decisions and consider what they mean for practitioners in the BVI and other offshore jurisdictions. What is estoppel? Estoppel is a term used to refer to a collection of legal doctrines, all of which are underpinned by the concepts of equity, unconscionability, and the prevention of injustice. The most common estoppels are as follows. Issue estoppel prevents a party from re-litigating an issue of fact or law that has been finally determined in earlier proceedings between the same parties. It promotes finality and efficiency. Estoppel by convention prevents a party from resiling from a common assumption of fact or law on which both parties have conducted their dealings, where it would be unconscionable to permit departure from that assumption. Proprietary estoppel arises where a person has been given an assurance regarding rights in property, has relied on that assurance to their detriment, and it would be unconscionable not to give effect to the expectation created. Estoppel by representation operates to protect against a departure from an assertion of fact or law intending it to be relied on, and which was relied on by the other party to their detriment. The narrow limits of issue estoppel. Whilst issue estoppel can have a very powerful effect, the Supreme Court has recently confirmed that it is a narrow doctrine, which has a different role than the abuse of process doctrine. See the rule in Henderson versus Henderson. Any unfairness created by a party failing to put some point in issue when they could have will be addressed by the Henderson rule. In Skatteforvaltningen, the Supreme Court considered whether Skatt, the Danish Customs and Tax Administration, could bring a fraud claim after an earlier claim for negligent misrepresentation had been brought and dismissed against the same financial brokerage business. The Court of Appeals treated the earlier decision as creating an issue estoppel, whereas the Supreme Court disagreed and unanimously allowed the appeal. The case gave the Supreme Court the opportunity to consider issue estoppel in more detail, and the court concluded that when carrying out an estoppel analysis, the question to ask is whether the issue was necessary and fundamental to the prior decision, with the pleadings being a critical consideration during this analysis. The court found that the factual and legal bases of the fraud claim were not traversable to the negligent misrepresentation claim. As a result of the court's findings, it was unnecessary for the court to look at ground one of the appeal, which argued that an issue estoppel could arise from a prior court's formulation of a legal principle or articulation of legal reasoning. From the perspective of a claimant, the case confirms that they can bring a new claim if it arises out of new or different legal or factual circumstances. Defendants will have to grapple with the fact that issue estoppel will only intervene in narrow circumstances where the issue decided in the prior proceedings were necessary and fundamental to the decision, and whether an issue arose on the party's pleadings in the prior civil proceedings is critical in deciding whether its determination was necessary and fundamental. The message to commercial litigators from this case is clear. Ensure your pleadings are precise and properly framed from the outset of the litigation. For offshore practitioners, particularly in fraud and asset recovery litigation involving overlapping parties or successive causes of action, Skatteforvaltningen is a warning against treating a previous dismissal as a general answer to a subsequent case pleaded differently. The comparison must be made between the pleaded issues and the precise factual foundations decided. Practical guidance for offshore litigators. Estoppel remains one of the most powerful doctrines available in an offshore litigator's arsenal. Whether it is being deployed to shut out attempts at re-litigation, to hold a party to a shared assumption, or to enforce reliance on an assurance regarding property or other rights. The more recent estoppel cases, including the earlier decisions of Guest and Tinkler, show that the modern English Supreme Court is policing the boundaries of estoppel. The court will insist on precise pleadings, transparent reasoning, and proportionate relief. If the limitations of the doctrine are properly understood and litigation strategy is planned accordingly, then offshore litigators will be well placed to deploy or resist estoppel effectively. The lesson from Skatteforvaltningen is that finality depends on precision. Practitioners should not overstate the scope of a prior judgment. Judicial reasoning may be expressed at a level of generality wider than the decision required. But Skatteforvaltningen makes clear that a broad proposition extracted from that reasoning is not, without more, an issue estoppel. The analysis should remain tied to the immediate foundation of the earlier decision. Where proceedings are successive and involve overlapping parties or related claims, practitioners should identify what has changed in the factual foundation and in the causes of action. Differences in the transactions, evidence, alleged conduct, legal characterization, or relief sought may show that the later issue is not identical to the one previously determined. The question is not whether the claims are connected, but whether the same issue arises for determination on the same necessary foundation. Estoppel by convention, as considered in Tinkler, carries its own practical warnings. Where parties in offshore proceedings have conducted their dealings on a shared assumption of fact or law for a prolonged period, whether in restructuring negotiations, insolvency administrations, or procedural correspondence, the risk of crystallizing an estoppel is real. Practitioners should expressly reserve rights when participating on assumptions they may later wish to challenge. Silence or acquiescence over months or years can harden a mistaken assumption into a binding one, particularly where the other party has acted to its detriment or gained a benefit on the strength of the shared understanding. Proprietary estoppel, as explored in Guest, adds a further dimension relevant to offshore trust, succession, and beneficial ownership disputes. Practitioners should be aware that even where an assurance and detrimental reliance are established, the remedy is not necessarily full enforcement of the expectation. The court retains discretion to fashion proportionate relief, and the remedy should not be out of all proportion to the detriment suffered. In offshore litigation involving family companies, joint ventures, or contested beneficial interests in property held through BVI or Cayman structures, this proportionality principle means that remedy design requires careful thought from the outset, both in framing the claim and in advising clients on realistic outcomes. Taken together, Skatteforvaltningen, Guest, and Tinkler illustrate a Supreme Court that is willing to uphold estoppel as a doctrine of real force, but only within carefully defined limits. These authorities are not binding in the BVI or Cayman Islands, but they are likely to be highly persuasive wherever the common law of estoppel applies. And practitioners who understand both their reach and their limits will be well placed to deploy or resist estoppel arguments in complex offshore disputes. Harneys does not practice the law of England and Wales.